Welcome again to our session on human rights in Ontario. I would like to begin by acknowledging the traditional territories of peoples of Turtle Island. The sacred land of which we are gathered today has been a site of human activity for 15,000 years. We acknowledge the land OCASI is situated on, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and Wet'suwet'en peoples, and is now home to many diverse First Nation, Inuit, and Métis people. This territory was the subject of Dish with one spoon, one pun belt government, an agreement between the Haudenosaunee and Ojibwe, an allied nation to peacefully share and care for the resources around the Great Lakes. We also acknowledge that Toronto is covered by Treaty 13 with the Mississauga of the Credit. Today's webinars offer an overview of the Human Rights Code, the legislation protecting individuals in Ontario from discrimination in their living, working, and service receiving environment. You will also gain an understanding of the rules that the three agencies that make up Ontario's human rights system: the Human Rights Tribunal of Ontario, the Ontario Human Rights Commission, and the Human Rights Legal Support Center play in upholding and enforcing the code. Additionally, this session will explore fundamental human rights concept and principle, including discrimination, harassment, and the duty to accommodate. You will also receive guidance on accessing further information and legal advice regarding human rights issue and what step to take if they believe their rights under the code have been violated. Today, our presenter, Melissa Mark, Research Counsel from Human Rights Legal Support Center. Welcome, Melissa. Melissa Mark is a lawyer who has worked at the Human Rights Legal Support Center since 2008. During her time at the center, Melissa had advised and represented numerous applicants appearing before the Human Rights Tribunal of Ontario on various matters. Since 2016, she has held the position of Research Counsel, supporting her colleagues at the center through conducting case-specific research and analyzing complex legal, procedural, and evidentiary issues. Melissa is a graduate of University of Windsor Faculty of Law and was called to the bar in 2006. She began her legal career in the Tenant Duty Counsel programs of the Advocacy Center for Tenants Ontario. As Tenant Duty Counsel, Melissa provided summary advice and representation to tenants appearing before the landlord and the tenant board. She is a past volunteer and board member of the Center for Equality Rights in Accommodations, now the Canadian Center for Housing Rights. There will be question and answer session at the end of presentation. We will try to address all your questions following order. We will prioritize questions submitted through the question and answer section. Please try to put all your questions on the question and answer section. After that, we will open the floor for questions where you can raise your hands and speak directly. Now I would like to invite Melissa Mark, and please, I will stop sharing my screen and you can share your screen.
Hi, good morning, everyone. Just bear with me for a minute while I get myself set up here. I've got a PowerPoint for all of you. I just need to share it. And there we go. So everyone can see my PowerPoint?
Yes.
Yes, excellent. Okay, now let me, okay. I have too many things on my screens. Hold on here. Just trying to pull my notes up. Okay. There. Okay, here we go. I think I'm ready to go. Thank you. Okay, so human rights in Ontario. Oh, and I wanted to thank Toronto for inviting me to come here today before I start. Thank you so much. I always love the opportunity to talk about the work that we do at the center and talk about the Human Rights Code and share it with folks such as yourselves, and you can use this knowledge in the work that you do, and hopefully further promote equality and anti-discrimination in the province. So here is the agenda for the training. So first, I'm going to talk about the Human Rights Code, the statute, the law in Ontario. What is it? What does it cover? And how do you access it? Next, I'm going to cover some key human rights concepts, some things that I think are really important for you to know out of the human rights law. Number 3, the Ontario human rights system. So there are 3 pillars, and Tarana mentioned them in the introduction. So I will talk about each of the 3 pillars and what they do. And then finally, well, almost finally, number 4 is the section I entitled The Code in Action. So I've just got a sample of some recent settlements and decisions that that my organization was involved in, to sort of give you an idea of what it looks like when the code is applied and enforced, and situations in which the code could apply. And then finally, last but not least, number 5 is the section I titled Resources. So this is where to go if you need further legal information or you need legal advice. And you'll see my note at the bottom of the slide. Please do not take anything in this presentation as specific legal advice about your particular situation. And I apologize to the ASL interpreter if I'm going too fast. If you need legal advice, you will know where to go because I will tell you in section 5. Okay, first, the Human Rights Code. Now, the Human Rights Code is a law of the province of Ontario. It is designed to have supremacy over all other laws in the province. So if any law is in conflict with the code supersedes it. And the focus of the law is to protect people from discrimination. And I will explain the concept of discrimination when I discuss human rights concepts in the next section. And in addition to setting out protections against discrimination, the code also has an enforcement mechanism in it by allowing people to file a complaint to the Human Rights Tribunal if they think the code has been violated. And I'll talk more about that process when I talk about the 3 pillars. Now, it's really important to understand, what does the code cover? It doesn't cover every single interaction you have with every single individual in the province. It is designed to protect people in relationships where there is an imbalance of power, traditionally speaking. So employer, employee, landlord, tenant, service provider, service recipient. So the code applies in 5 social areas. This is what we call them, social areas: employment, housing, services, goods, and facilities, contracts, which doesn't come up that often, and membership in a vocational association, like a union. And these are what we call the grounds of discrimination that are expressly set out in the code. Some of these grounds are defined in the code, and some of them are defined in the case law. But they're all seen as personal characteristics upon which an individual may be vulnerable to discrimination. And discrimination, again, that word, what does that mean, legally speaking, under the code? Here's our segue into the human rights concept section. So discrimination under the Human Rights Code is considered to be differential treatment that results in you being denied something, excluded from something, or some sort of disadvantage because of one of those code grounds. It is not necessary for there to be intent to discriminate. A person can unintentionally discriminate. And the code ground need only be a factor in the alleged differential treatment for it to be considered discrimination under the code. So, for example, a lot of our cases are employment cases. And we'll argue that a person was fired on a discriminatory basis because a code ground was a factor. And the employer will say, well, we also fired them because of shortage of work or whatever. The code ground need only be one factor. It doesn't have to be the only factor or even the main factor. So some things to keep in mind. Now, there are 2 types of discrimination in the code. The first is what we call direct discrimination. So that is like the examples I provided. The code ground was a factor in the differential treatment that you're trying to argue is discriminatory. And a very clear example, we don't see these cases that often anymore. Sorry, we don't hire women for that position. That would clearly be discriminatory because the code ground of gender was a factor in the denial of the position of employment. Now, there is another type of discrimination which can be a bit more difficult to identify. And we call that constructive discrimination or adverse effect discrimination. And that is where you have a rule or a requirement that appears on its face to be neutral, but it is discriminatory in its effect on somebody based on a code ground. And I have some examples here. So the policy, everybody has to wear the company cap at work. What if the employee has a religious headdress like a hijab or a turban? The rule at first glance doesn't appear to have any issue with it, but it's discriminatory in its effect, in its impact, based on a code ground. The computer assigns everybody's work schedule, and you just have to take what you're given. This was actually a case we had where our client was the sole caregiver of a disabled child with very high needs. And she had worked the same shift for years, and her employer got a new computer program. And they said that she just had to take what she was given. That is constructive discrimination. Now, arising out of the concept of constructive discrimination is the duty to accommodate. You may have heard this term before, so I'll explain what it means under the code. So where you have a situation of potential constructive discrimination, the organization has a duty to accommodate the impacted person to the point of undue hardship. I know that's very legalistic. Let's unpack that a bit. So undue hardship is a very high threshold. And in the code, it says you can only consider cost, which must be substantial, so substantial that it could impact the essential nature of the enterprise. And the respondent would have to lead evidence on that, or health and safety risks. So let's take that example again of the rule about wearing a cap. If it's just a baseball hat, it would be very difficult for the employer to argue undue hardship. If it's a hard hat and we're dealing with a construction area and the employer is required by health and safety laws to have their employees wear hard hats in that area, that's a different story. So that's undue hardship. And so that duty to accommodate is very broad. And a part of the duty to accommodate is the duty to inquire. This normally comes up in cases involving the code ground of disability and the social area of employment. So generally speaking, organizations are not required to accommodate a disability they are unaware of, But you could have a situation where the organization knows enough that they ought to have known that something was up. One example that from one of my cases was I had a 20-year employee who for 18 years was an exceptional employee, never absent, never late. And then all of a sudden he starts calling in sick, and some days he forgets to call in. And he's providing doctor's notes, which don't have much information in them. But I argued that, based on 18 years of exceptional service, and then now you have these doctor's notes, there was a duty to inquire there. So that's how that concept arises. Two more final concepts before I move into the more practical stuff. Harassment. Now, the term harassment is quite often overused. It has a very specific legal meaning under the code. So, and this is defined in the code as well. The definition in the code is engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. So this does not cover a boss or a coworker or a landlord being mean to you. And this is a struggle that we have sometimes with clients where they the code doesn't mean that everybody has to be nice to you. Unfortunately, a code ground has to be engaged in the comment or conduct for it to be harassment under the code. So the second point is the definition does say course of vexatious comment or conduct, which would mean more than one incident. But sometimes if an incident is particularly serious, it can be considered harassment, just that one incident alone. And because the definition says known or ought reasonably to be known, you don't have to object to the conduct in order to prove harassment. The tribunal recognizes that, again, that power imbalance, people may not feel comfortable confronting their harasser about their conduct, and they may sometimes even appear to be playing along. They may laugh to protect themselves. That does not mean that they can't prove harassment before the tribunal. And one final concept, reprisal. So this is a separate section of the code. Different from the sections protecting against discrimination and harassment. What this is designed to do is to provide protection against any sort of retaliation against you for trying to enforce your rights under the code. One really common example we see is an employee tries to make a harassment complaint at work or make a request for accommodation, and then they suddenly get fired. We would then argue that the termination was reprisal. And that would be an additional violation of the code on top of the discrimination or harassment. Awesome. Now, quickly, what is not a human rights issue? This is also important to know. Issues related to general employment laws, minimum wage, breaks, overtime, legitimate counseling or discipline from an employer or a supervisor, general harassment or bullying, as I mentioned earlier, where it's not attached, where it's not in any way connected to a code ground. And then any interactions outside of those 5 social areas I mentioned earlier. There we go. So those are the concepts. Let's talk about some more practical, concrete stuff. So the 3 pillars of the Ontario human rights system. The first one I'm going to talk about is the Human Rights Tribunal. You can think of the tribunal as a specialized court. All they hear is applications filed under the Human Rights Code. And they have a number of members who are appointed to the tribunal, who handle human rights applications either through mediation or adjudication. And I will talk about both of those coming up. I have one slide coming up on the tribunal's process. The Human Rights Commission. People often get us mixed up with the commission. But we play 2 very different roles. The commission looks at human rights as a whole across the province. They do inquiries. For example, they did one on anti-Black racism in the Toronto Police Service. They draft wonderful policies. I'll be talking about them in the resources section on each social area and ground and any current human rights issues that are at play at a given time. They can also file applications and intervene in any application that they want. Intervene means participate in the proceeding. So the commission is macro level, and we, the Legal Support Center, are micro level. We work with the individuals whose rights have been violated, who want to file an application. And I will talk a bit more in a bit about the specific support we provide. We only provide assistance to applicants. So that's the people filing applications. So employees, tenants, service recipients, and not employers, landlords. Our services are free, and we serve the whole province. Now, here's the process. So the process starts with an application. The Tribunal has forums on their website. I've got their website on a later slide. You download the form, you fill it out, you file it. Most people are able to complete the application on their own. It's designed to be user-friendly. And there are guides. There are guides for filling out the form on the Tribunal's website and on our website. And our intake staff, we have an intake line. Our intake staff are always available for questions on how to fill out the form. We have a very limited capacity to draft applications. And just due to high demand and lack of people, lack of staff, we would love to do more, but we're only human. We do draft applications in situations where the individual would not be able to do it on their own. Just due to the nature of the case, maybe it's very complex legal issues. Or there are some barriers, such as a language barrier or a disability. So after the application is filed, usually the next step is the response. The person against whom the application was filed then fills out their own form and files it with the Tribunal. Sometimes the Tribunal may identify a potential issue with the application before that step. And if that happens, people should call us definitely call us to get advice on how to deal with that. After the response, then the applicant has an opportunity to file a reply to any new issues that were raised in the response. So for example, the respondent says, we didn't fire the person for a discriminatory reason. Actually, we fired them because their performance was terrible. And here are 5 examples. The applicant might want to file a reply to deal with those new issues raised. And then at that point, the matter gets scheduled either for a mediation if both parties agree to it, or a hearing. So a mediation is where the parties just try to come together and work it out themselves. And there will be a member of the tribunal there working as a mediator to help the parties. If the parties do reach an agreement, then the mediator drafts a document we call the minutes of settlement, and it sets out all the terms, and everybody signs it, and it's over. If they don't settle, then they go to hearing. And a hearing is like a trial. If you've seen a trial on TV, any of those American legal shows, there's witnesses testifying and documents tendered as evidence. And if there's lawyers involved, lawyers making legal arguments. And it's at those later stages, the mediation and the hearing, where we try to focus our services and support. So that's really where people need a lawyer for the mediation or the hearing. Yeah. If a case has merit and we have a staff member available to go, then we'll go. So that's the process. That's the pillars and the tribunal process. Everyone good so far? Excellent. So I'm just going to talk about a few of our cases, just to give you a sample of how all of this looks. Now here, it was what we call an early intervention. Sometimes we'll have somebody call intake with a situation that needs to be resolved immediately. And can't wait to go to mediation or hearing years down the road. So this client, she identified as African Canadian. She had applied for an apartment, but when the landlord saw her, suddenly the unit was already rented. She had her friend call, and the friend was told, oh, the unit's still available. So our intake manager contacted the landlord and explained that that looks to be a violation of the code. And the owner agreed to accept the rental application. Here was a matter we settled at mediation. Now, our client was a recent newcomer to Canada. She was experiencing harassment in her workplace based on her place of origin. She was then targeted for for discipline and overly monitored in her work. When she complained, she was fired. So we were able to help this woman at mediation. This matter settled for $25,000, a positive letter of reference, and the employer agreed to review their practices and their policies to make sure they are in compliance with the code, to make sure this didn't happen again. Okay, and a few decisions. So these are matters where we represented the applicant at hearing. Now, Ben Saad, he was from Tunisia. He was working in Canada, got injured at work, and which required him to take some time off work to recover. He then got fired for attendance issues. And we represented him before the tribunal and argued that was discriminatory because those absences were related to his work injury, his disability. And the tribunal agreed. So they upheld that application. They awarded Mr. Ben Saad $20,000 and ordered the respondent to develop a human rights policy and make sure their managers got training on the human rights code. Now, the MADCOR decision here was 2 Muslim tenants, so they were a couple. They had given their landlord notice that they were going to leave their unit, and they asked for accommodation with respect to scheduling showings of the unit for new tenants. They only asked for extra notice to make sure their prayer times weren't interrupted, and to make sure that Mrs. Melly was able to put her job on before anybody came. So a very simple request. They also made additional requests about making sure everybody took their shoes off so that they wouldn't be walking with shoes on where they prayed. And their landlord was not very nice and didn't listen. And the tribunal found he violated the code. Now, this decision dealt with really terrible sexual harassment and assault by the applicant's manager. In employment. Now, the applicant here was awarded $75,000, which is one of the highest awards the tribunal has made. So that's just to give you a sampling of how the tribunal applies the code and the types of cases that we take on at the center. So now I'm going to give you some information on where to get more information and to get legal advice if you need it. So first and foremost, it's us. So we provide advice at all stages of the process. It's not just when you're filing an application. People will often call us and say, I just had this thing happen to me at work today. Is this a violation of the code? What should I do? My doctor told me to ask for accommodation at work. What does that mean? How do I even do that? So we provide that advice. So we have a 416 number and a toll-free number. Our phone lines are open 9 to 5, except for Thursdays. We do meetings Thursday mornings. So it's open 2 to 5 on Thursday. And on our website, we also have a lot of general information, which I've shared a lot of with you already today. There's also detailed how-to guides on every step of the tribunal process. So that's our website and how to contact us. Now, our two sister organizations, the other two pillars of the system. So here's the Tribunal's website. You can find the application forms here, as well as detailed guides on the process and policy directives on the process. So a policy directive is a document which sets out rules for the tribunal's process. And then the Commission's website. They have excellent policies on each social area, on each code ground. And it's the Commission's role to provide guidance on how the code should be interpreted. So they're excellent for for information. And I've relied on them in hearings before the tribunal before. And they also have a lot of public statements and their reports on their website. Now there's Legal Aid Ontario. There are some clinics that do human rights applications. And if somebody were to come to us with an issue that doesn't engage the code, but may be something that a clinic can deal with, like a housing issue not related to the code or employment. We often refer people to legal aid. And they've got a website where you can get more information on their services. And they have a number you can call to see if you're eligible and where you should go. Because they have so many clinics. The entire province is carved up into catchment areas, and each area has a community clinic. And then there are specialty clinics as well. Like there is one for people whose first language is Spanish, or are of Chinese ancestry, or people dealing with tenancy issues. The Advocacy Center for the Elderly, which deals with elder issues. They're a really great resource. So I just want to make sure you're aware of them. There's also pro bono. So pro bono is where you can get free legal advice and representation. They don't do criminal or family or immigration law, though. So that's good to keep in mind. I also want to make sure you're aware that the Law Society of Ontario, which is the body that regulates and governs all lawyers and paralegals in the province, they offer a referral service if you need to find a lawyer. These lawyers you would likely have to pay for, though. And finally, I wanted to make sure you're aware of CLEO. So the Community Legal Education Ontario website is excellent. I use it myself for areas of law I'm not familiar with. It is really well organized and very user-friendly. So it's set up in 2 sections. They have their publication section, and then steps to justice. And the Steps to Justice website, which I've helped out on the human rights materials for them. But it's very detailed step-by-step instructions on virtually every legal problem you can think of. So, and I believe that is, yes, that's my last slide. So we'll get organized. I'm going to stop sharing my screen.
Thank you very much, Melissa. That was great, very clear and detailed. I don't see any questions on the question and answer section. Probably all your presentation covered most of the point with scenarios, examples, and I really appreciate you accommodating our sign language interpreters work as well. Thanks a lot. I will open the floor. Please raise your hands if you have any question, because I don't see any questions on the question and answer section. We will give just a minute for that. People prepare their questions. I see Michael.
Yeah, I have a question. When you were discussing the duty to inquire, you gave an example, for example, where it was a duty of the employee to inquire when there were a lot of doctor's notes, I think, or absences. So where does the line come between the duty to inquire and privacy?
Oh, well, that's a very good question, and it's a very case specific. The answer to that question would be different for every single case. So that depends.
Okay.
That's the classic lawyer answer.
Well, you are a lawyer, so I get that.
Yes. Yeah.
Okay.
Thank you, Michael. Even though you didn't get specific response to your question. Okay. Who else? It seems we will be finishing our session. I see Otamen. Please,
Yes,
you can unmute
yes,
yourself.
yes. Hi. I have two questions actually. The first one is, I do work for Franco Queer, so we do help LGBTQI plus French-speaking members in Ontario, which most of them are immigrants. So, new immigrants or asylum seekers or refugees, and we've been hearing about some issues they do have for housing or for employment. So is there a way we could get like all the information you just stated about like the different instance or how to support them when they come to us with problems they have to face regarding human rights? This is the first question. The second one is, what would you do if when I came in actually in the country 6 months ago, I had I applied for an app that kind of like put in contact employers and employees, like potential employees. And I was told that all my experiences abroad were not valuable in Canada, even though I worked in France and I worked in China and in the US. And instead of like just giving me what I've applied for, they told me, oh, if you're new immigrants, I only can put you in contact with employers for cleaning purposes or for, how do you call it? I'm going to say in French, d'MPP. So like it's when you're in a nightclub or like in a bar and you stay in the bathroom, so you have to clean. I don't recall the name. And after that, when I complained about it and I said that I would take legal action, they just kind of like let me get into the app, but I don't get any offers. They kind of like just muted my account. So I was wondering, I'm kind of like, I moved past that, but I was feeling like if I don't do something about it, and as I know how, like, if I don't do stuff about it, how are new immigrants going to do about this kind of like encounters? So these are my questions.
So, okay, so answer the first question. Feel free to tell people to call our intake line.
Okay, but they're
That's-
only like French speakers. Do you guys have services in French too?
Yes, yeah, we are
Okay.
required. We are an agency of the provincial government. We are required by law to provide services in French and English. So we do have bilingual staff.
Okay.
Yeah. Yeah, so that's fine. They can, yeah. And we do have we have a French queue. So in it, yeah. So like they'll call and they can choose French, and then they go in the French queue and we'll speak to our French staff. Yeah.
Okay. Okay.
Yeah,
That's
fine.
amazing. Okay.
Oh, and we also, because it's sort of a related topic, we also, well, oh, you know what? That's probably not going to come up your work. So never mind. Second
No,
question.
just tell me. It's
Oh, no,
it's
no,
good
no,
to
no,
know
it's
because
okay.
I always like
No, well,
the
well-
aim is to give the most but like the most possible
Yeah.
information to our
Well, no,
clients so they
actually,
could
I
like
thought about it because we do offer another service, but this is probably not something that any newcomer will ever need because it's Indigenous specific. So it's going to be people whose ancestors have been here for a very long time. So
yes, but
no newcomers. Yeah.
but we also have like as part of the 2S LGBTQI plus, we have indigenous
You
members
would
as
have
well.
two spirit. And yeah, so okay, so if that's the case, if you do any work with Indigenous people, they can. We have the Indigenous services team. We have Indigenous staff at all levels.
Okay.
So they can, yeah, so they can just speak with Indigenous staff if they want.
Okay.
So those are the two specialized streams that we offer.
Okay.
Yeah, the French service and the Indigenous services team. Yeah. Yeah, so that was my first question. The first answer. Second would be it's hard for, like, I'm not in a position to give legal advice just because I don't know all of the details. You may want to call us.
Okay.
You may want to call us about that, actually.
Okay.
Yeah.
Because I was
I think
discussing
that
it
would
with
be
my
best.
colleagues. I was discussing it with my colleagues at Franco Queer, and they were like, if you don't do it, like if you don't do something about it, and you're trying to like doing social work, what do you leave to other people not knowing the rights to do about? Like,
exactly. Yeah. When did this happen? One thing I did not mention earlier, you have to file an application in 1 year of the discrimination. Okay. So
that happened last November.
okay. So just keep that in mind. You have 1 year.
Okay.
Yeah. Okay.
Thank you very much, Melissa.
Yeah, no problem.
Appreciate it. Thank you.
Thank you, Melissa and Othman. Sorry if I don't pronounce your name correctly. Please, those who already asked the question, put down your hand so I can. I see, Michael, you have another question or your hand was raised previously? Okay, I cannot hear from Michael. Then I will ask Kingsley.
Oh, sorry, I thought I'd taken it off. Sorry.
Oh, okay. I see Kingsley. Laura. Grace. I see hands. Okay. No hands. So.
I was just very thorough. I was very thorough in my presentation.
Yes, thank you so much, Melissa, for your time and the presentation. It really was very informative and detailed. I really appreciate the center for spending time with us. And thank you, everyone. I would like also to thank Kate and Francis for your services. We'll see you next time. Thank you, everyone. Bye. Have a good day.
Bye.